Hey everybody, John Skiba here from the Consumer Warrior YouTube channel. And this is video number 5 in a 5-part series I've been doing this week on defending debt collection lawsuits, particularly those bought by junk debt buyers. I'm filming this in 2022, so this is updated with all the newest and latest information, strategies, and approaches that I use as a lawyer in the state of Arizona when I help clients defend against debt collection lawsuits. Now, this one is one where I've gotten a lot of feedback where people want to know this. You know, there's drafting the documents, going through the whole discovery process, and leading to the big show. It's time for trial. But there's a lot of apprehension, and I get this. Lawyers get nervous for trial, and so I wanted to go through some of the basic steps of the trial process and what you can do to prepare to get the best outcome possible. If this is your first time here, please check subscribe. That way you'll be notified each and every week when I put out new videos that'll help you with your serious debt problem. All right, let's talk about trial. I can tell you if you have a trial coming up, you're going to be nervous. I remember as a young lawyer, I was super nervous, and just even going to court for routine things. It's public speaking. it's a perfect storm of public speaking. There's a lot on the line. Technical speaking, you have to have a lot of knowledge. You're going to get questions, and it can be just stressful all around. So the first thing I want to talk about, and I'm going to give you we'll go with 4 tips. 4 tips about getting ready for trial. The first one, as far as your preparation goes, the best thing you can do is go to the courthouse and watch somebody else's trial. Now, I know that we're here in the, dealing with the COVID pandemic. In some jurisdictions, that's not going to be possible, but you might be surprised that there are still a number of cases that are going on where civil trials are being held. And so you can contact the court where your case is being held, ask the clerk if there's any trials coming up, and you want to see trials where they're dealing with the type of creditor that you're dealing with. If it's a junk debt buyer like Midland and Portfolio, Cavalry, you want to go watch that. Or if you're being sued by an original creditor, like an American Express, Wells Fargo, something like that, you want to make sure you get those down because the courts may treat those different and there's going to be different arguments. And court hearings are public proceedings. You can just go sit in the back, take some notes, and watch for how the judge rules on things, how the judge handles the court, the procedure, the process. I remember as a brand new lawyer, I was working with I had a partner who was the partner in the law firm, and he took me to court with him one day. And I'd always been so nervous about going to court. And when I actually saw what it was, sitting there watching him, I thought to myself, I can do that. Of course, I didn't know what I was doing yet, but I thought I can do that. It took some of the mystique and some of the apprehension away of actually going through the court process. So my recommendation, find the court and see how the court deals with objections, how the court wants you to handle exhibits. You may even talk to the clerk of the court, how they typically handle things as far as documents and exhibits. You can get a lot of insight in there that will put your mind at ease as far as just the general process. Now, second thing I want to talk about when you're getting ready for trial, you need to remember who has the burden of proof. And what that is, in a legal proceeding, one party bears the burden of proving its case against the other. In criminal court, you hear when there's a case that's always, you've got to show beyond a reasonable doubt. The prosecution has to show beyond a reasonable doubt. The defendant in a criminal case doesn't have to disprove anything. They just have to see if the prosecution can prove their case beyond a reasonable doubt. And that's why you often see the defendants in criminal cases do not take the stand, because they don't feel there's any real need to, and it would actually harm them more than help them. In civil cases, there's a burden of proof as well, and it's on the plaintiff, it's on the debt buyer, the collector. They have to prove their case, but there's a different standard of proof. In criminal cases, it's beyond a reasonable doubt. In civil cases, it's a preponderance of the evidence. It's a big difference because a preponderance of the evidence is really like 51% for one side, 49% for the other. Beyond a reasonable doubt is a huge standard. That's more like 90% to 10%. Here, in civil cases, all the plaintiff has to do is prove essentially that it's more likely than not as far as the elements of their case, and then they can win. But that being said, that's how bad junk debt buyer cases often are. Is they struggle when they get in there to be able to prove all the different elements of their case. So remember when you're going in, it's up to the plaintiff to prove their case. You don't have to disprove anything. Now, you're going to have your opportunities to object and to cross-examine, but you've got to remember that that's where it is, and you shouldn't be coming in there expecting to, have some kind of presentation on it. As far as you're there to kind of pick apart their case, not the other way around. All right, the third thing is procedure. When you walk in the courtroom, I remember the first time I walked into the courtroom, I didn't know what side of the room to sit on. I can tell you this, the plaintiff sits by the side where the jurors' chairs are, the defendant sits on the other side. That's one of the biggest things. That was one of my big concerns as a new lawyer. The procedure in a trial, though, is the first thing there are is opening statements. The plaintiff will go first and give a brief opening statement about what their case is about. You will then have an opportunity to give a brief opening statement about what your defense is about. And then the case will go. The plaintiff goes first. They're going to call any witnesses. After they're done asking their witnesses questions, you can then cross-examine those witnesses if you have questions. And once they've gone through all of their witnesses, they will then at that point stop stop their case. They'll rest. Then it's your turn to put on any evidence that you have. And you can evaluate at that point if they've put on enough evidence or not. And if you feel it's necessary, then you can call your own witnesses. Now, the last area is objections. This one can get kind of tough. But I can tell you with most courts, if you have objections to evidence that's coming in, the plaintiff will offer the exhibit into evidence, and the court will ask you if you have any objections. That's where you can raise that at that point. Now, that's beyond the scope of this video, but if you want to learn more about how to raise objections, how to do the trial in a lot of detail, check down below. I have a link to a tutorial and some templates I've put together that'll help you through that process. Just go in there, have confidence. You can do this. You can be a consumer warrior. You can get this done, get this out of your life, and move on. Thanks for watching today. We'll talk to you soon.